she's essentially arguing for the magazine ban portion of this, that
Correct.
magazines are magazines that hold more than 10 rounds of ammunition are not required for the operation of a firearm. And so therefore they may not be covered by the core of the Second Amendment, that banning them doesn't implicate the Second Amendment really, because they're not wholly necessary for the use of firearms. What first, like, obviously I assume you disagree with that basic concept, just off the bat there.
Absolutely, 1,000%. First of all, you and I know that criminals will not abide by Measure 114 in Oregon or in any other state in the Union or the territories of the United States. They don't abide by any of these rules and regulations, and they will use whatever it is that they want to commit their crimes. These restrictions only apply to law-abiding citizens. And in applying these restrictions to law-abiding citizens who will maybe reluctantly follow the law because they are law-abiding citizens and they hate it, but they don't want to violate the law. That's why so many of them work to change these bad laws by supporting Gun Owners of America and all of the other organizations that are fighting to protect their rights. But the fact of the matter is, citizens throughout the country use firearms with standard capacity magazines, handguns that hold 17 rounds like the Glock 17 and 15 rounds like the Glock 19 and 12 rounds and 20 round magazines and 30 round magazines to protect themselves all the time. So what the promoters of this measure are okay with is that they are okay with those citizens who choose to use those firearms to defend themselves to go from successful survivors of crime, and they're okay with putting them potentially in the victims of crime. Because in Bruin, Justice Thomas pointed out that millions of people throughout the country every year use firearms to successfully defend themselves, oftentimes without ever having to fire a shot. But there are cases where shots have to be fired, and lawful citizens should be given every advantage that they possibly need. They should not be handicapped by these policymakers who are arbitrarily coming up with these numbers. Most people don't know that the number 10 came up here in California when they banned large capacity magazines, they call them. It was like, okay, guys, we're writing this legislation. How many rounds do we allow them? 1, 2, 3. Well, I ran out of fingers, so it's going to be 10. That's what we're going to limit it to. And that's how it came up. It was an arbitrary number. In New York, we know they tried to reduce that to 7.
7, yeah.
And so
other states have it at 15, of course. So yeah, I mean that certainly makes sense as the moral argument for why these bans are wrong. But what about the constitutional argument? Why is she wrong to say that these magazines aren't protected by the Second Amendment? They're outside the Second Amendment. Is it because they're so common and they're used for lawful purposes? Is that what you're sort of the gist of why these would be protected?
Yeah, that's a great question. And people, when you take into account the case in New York that had to do with, the electronic tasers and things like that, where they were trying to control them, right. And the court the Supreme Court held that those weapons were qualified as weapons in popular use and therefore protected by the Second Amendment. There's no secret that magazines are an essential part of the operation of semi-automatic firearms and even some bolt-action firearms. And since they are essential, they are considered the same as weapons, and they are in popular use. As you pointed out, there are hundreds of millions, if not potentially 1 billion magazines owned by people in the United States right now. So anybody who will try to argue that they are not in popular use for lawful purposes is just not being honest.
Yeah, right. That, and I mean, that does seem in line with what the Supreme Court has held on both handguns and, as you were talking about with 2016's Sertano, stun guns as well. There are only a couple 100,000, I believe, in that case that they identified, but they still said that was common use. And there's way more magazines that hold more than 10 rounds
Yes.
out there than a couple 100,000. So, obviously there's not necessarily a number that the Supreme Court has put on it, but certainly it seems the most popular kind of magazine is one that holds more than 10 rounds, and so banning it, yeah. But so and then back to her argument on permit to purchase, where she says this is here. Let me give you a quote directly from her ruling. Measure 114's permit to purchase scheme is a shall issue permit scheme based on objective standards and is therefore presumptively constitutional under the holding of Bruin. I guess first point there, isn't there a provision in this ballot initiative that does give subjectivity to people issuing these permits? That, if they determine you're a threat to yourself or others, they can deny you a permit even if you haven't been convicted of anything or involuntarily committed?
Any of these schemes like Measure 114, there's no question that there is some level of subjectivity in the issuing of permits, the time frame with issuing the permits, the amount of money that's required in order to gain the permits. And if they can give permits, they can also take them away. So there is definitely a level of subjectivity from our perspective in the scheme that they have come up with. But for people who are trying to understand, well, what's wrong with requiring a permit to be able to purchase a firearm? Well, how about if the government said that you have to submit a form and become registered if you wanted to go to church? Or if reporters had to register before they went to work for some news agency and pay a fee and have a background check in order to exercise their First Amendment rights of freedom of speech and freedom of expression and freedom of religion, people would say that would be unconstitutional. Ding, 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 ding. It's the same thing with the Second Amendment. They are trying to say that we Americans, those of us who obey the law, are guilty until proven innocent. So, and that's not the way law works in America. We are innocent until proven guilty. And requiring us to go through all of these steps is just backwards. And we have to fight it here, because if they're successful with making these requirements on the Second Amendment, there's no question that they will be inching towards the First Amendment as well. And we see that in government's intrusion into the freedom of speech, whether it's social media, whether it's the news media, what you say, what is considered unconstitutionally protected speech. That is a dangerous path, and I think that that is where they're going with their restrictions on the Second Amendment and requiring people to prove that you are a law-abiding citizen before we're going to allow you to open your mouth and say something, or to obtain a firearm to use to protect your life, your family, your homes, and your businesses. You're going to have to prove to us, the government, before we allow you to exercise that right. So it's the dangerous waters that the courts are the policymakers and some of the judges in the court system that are treading on, and we need to be aware of that.
So that all makes certainly makes sense, but I guess my thought on this, or one area where I find her ruling interesting, is that the Supreme Court did, or at least, that concurrence with Roberts and Kavanaugh does go into how they aren't questioning, shall issue gun carry permitting, even after they put gun carry on the same level as just gun ownership in terms of what's protected under the Second Amendment. And so, I wonder, assuming for a moment that Oregon can convince the court that the section that allows them to, deny permits based off of what appear to be more subjective measures, like whether the police think you're a danger to yourself or others based on something other than actual convictions or commitments that would come up in a background check. If they could convince the court that this was closer to a shall issue regime in permitting to purchase, I do wonder whether or not that will be viewed as in line with Bruin because of that concurrence. And I'm interested in why you think it wouldn't be.
Well, that's a great question, and I'll answer it like this. The Supreme Court in Bruin said that the Bruin decision is not a straitjacket on government policymakers to pass measures having to do with firearms, but it is also not a blank check. And then and the policymakers that are proposing these measures, like 114 in Oregon and other gun control measures that are popping up throughout the country, they stop at the comment from the court that it is not a straitjacket. It is not a prevention of these things. But the court also said that it's not a blank check. And then it gave the ability for people to evaluate whether it's permissible or not. They said any law that is being considered on the books now has to have a historical analog. So they said text as informed by history and tradition going back to 1791. If there was a law that existed at the time, then the law that is being considered now can be evaluated, whether it has that historical analog. If no historical analog exists, by definition, the law is unconstitutional.
Yep.
The people that are trying to promote more gun control hate that. They ignore the rest of that. They come up with all of these arguments. Well, they just use muskets and these kinds of things back in the day. How would they know? And well, you know what? The law of the land is very clear. And there's very little interpretation that's required in order to apply the standard that the Supreme Court issued. And every time that standard is violated, that measure is going to be taken to court. And that is exactly the case with Measure 114 in Oregon.
Okay. So essentially just the idea is that that's the standard. You articulated the standard, I think, very well for what Bruin says you're supposed to do when judging a Second Amendment case. Mm-hmm. And that matters much more than, dicta, basically all the other stuff that they wrote in concurrences or whatnot that just sort of gives more of their thoughts, but is not necessarily binding in terms of how you're supposed to judge these cases. Is that a good summation of what you're saying there?
Absolutely. And I think that's being born very clearly in that there have been multiple lawsuits, cases throughout the country since the Bruin decision, and judges, even though they've been appointed by Presidents Clinton and Obama and Biden, have ruled for the Second Amendment because of the new standard that they are required to use. And therefore, gun control measures throughout the country have fallen on the dung heap of legislative history as being invalid and a clear violation of the Second Amendment. So that is absolutely being borne true. And that we will keep finding these Energizer Bunny policymakers and judges who will try every way they can to get around the clear standard that is now set by the Bruin decision. And we will be prepared to fight them every step of the way.